Hi everyone, welcome back to Hands-Free Studying for the MBE with Brainscape. Today's video is about evidence, so get ready and let's get started with our first set of cards covering presentation of evidence. Question 1. The federal rules of evidence apply to what type of proceedings? All civil and criminal proceedings in federal courts. Question 2. Do the common law rules of evidence apply on the MBE? No, only the federal rules of evidence apply on the MBE. Question 3. When do the federal rules of evidence not apply? The federal rules of evidence don't apply in 7 scenarios. The first is when you're determining preliminary questions of fact regarding the admissibility of evidence. 2, during grand jury proceedings. 3, in preliminary examinations in a criminal case. 4, for sentencing, probation, and bail hearings. 5, in summary contempt proceedings. 6, for the issuance of warrants and criminal summons. And lastly, 7, in extradition or rendition proceedings. Question 4. In regards to evidence, what does the judge decide? The judge decides preliminary questions about the competency of the evidence and whether evidence is admissible, witnesses are qualified, and whether privilege exists. Note, except for deciding whether privilege exists, remember that the judge is not bound by the federal rules of evidence when deciding preliminary questions. Question 5. When does a preliminary hearing on the evidence need to occur outside the presence of a jury? If, first, the hearing involves the admissibility of a confession. 2, the defendant in a criminal case is a witness or so requests. Or 3, if justice so requires. Question 6. In regards to evidence, what does the jury decide? The jury looks at the weight and credibility of the evidence. Question 7. Under what circumstances can an evidentiary ruling be challenged? The ruling can be challenged if it affects a substantial right of the party. Question 8. What are motions in limine? Motions in limine are pre-trial motions seeking to exclude certain pieces of evidence. Question 9. If a party believes that evidence was erroneously admitted, how can the issue be preserved for appeal? The party must, on the record, timely object or move to strike, and state the specific ground for the objection, unless it was apparent from the context. Question 10. If a party believes that evidence was erroneously excluded, how can the issue be preserved for appeal? The party must make an offer of proof, which is an explanation on the record as to why the evidence is relevant and should be admitted, unless the substance was apparent from the context. These upcoming evidence questions cover witnesses and impeachment. All right, let's get started. Question 1. What is required for a witness to be considered competent? The witness must first take an oath to testify truthfully. Second, testify based on personal knowledge. 3, the witness must not be incapacitated. And 4th, the witness must give testimony as to facts, not opinions. Remember, under the federal rules of evidence, witnesses are presumed competent. On the MBE, be wary of answer choices that say the witness is incompetent, when instead the witness is just biased. Question 2. When is a lay witness allowed to testify as to opinions? Lay witnesses can testify as to opinions only if they are based on first-hand knowledge and rationally based on the witness's perception, helpful to clearly understanding the witness's testimony or determining a fact and issue, and lastly, not based on scientific, technical, or other specialized knowledge. Question 3. Can a judge testify as a witness? No, never. Question 4. What may a juror testify about after trial? A juror can testify about extraneous prejudicial information that was improperly brought to the jury's attention, any improper outside influences, mistakes in entering their verdict, or if there was an overt racial animus that was a significant motivating factor in the jury's decision to convict the defendant. Question 5. What is a juror prohibited from testifying about after a trial? A juror cannot testify about statements made during the jury's deliberations, about the effect of anything on a juror's vote, or any juror's mental processes concerning the verdict or indictment. Question 6. What is the process for present recollection refreshed? A witness can be shown a document to refresh his memory if, first, the witness cannot recall the answer to the question. The witness then says that seeing a particular thing will refresh their memory. And lastly, after viewing the thing, the witness testifies that their recollection is refreshed. Remember that present recollection refreshed is not an exception to hearsay and will generally not be admitted into evidence, unlike the hearsay exception, past recollection recorded. Question 7. If a party refreshes the witness's present recollection with a writing, what is the adverse party entitled to under Federal Rule of Evidence 612B? The adverse party is entitled to first, have the writing produced at the hearing. Second, they're entitled to an opportunity to inspect it. 3, they can cross-examine the witness about it. And lastly, they're entitled to introduce into evidence any portion that relates to the witness's testimony. Question 8. If privileged information is used to refresh a witness's present recollection, is the party required to comply with Federal Rule of Evidence 612B? No, most courts find that the privilege is waived and allow inspection by the adverse party. Question 9. Can inadmissible evidence be used for present recollection refreshed? Yes, you can use inadmissible hearsay or otherwise inadmissible evidence. Question 10. What is past recollection recorded? Past recollection recorded allows a witness to read a prior writing or record to the jury if, first, the witness once had personal knowledge of the writing, 2, the witness now forgets the writing, and showing the writing to the witness does not jog his or her memory, 3, the writing was made by either the witness or adopted by the witness, 4, the writing was made when the event was fresh in the witness's memory, and 5, the witness can attest that when made, the writing was accurate. Remember, this is a hearsay exception, and thus can be admitted into evidence. This is unlike present recollection refreshed, which is not a hearsay exception and generally not admitted into evidence. These upcoming evidence questions cover relevancy, Rule 403, and character evidence. All right, let's get started. Question 1. What is relevant evidence? Relevant evidence is evidence that has the tendency to make a fact more or less probable than it would be without the evidence, and evidence where the fact is of consequence in determining the action. Question 2. What is logical relevance? This is evidence that has a logical tendency to prove or disprove a fact of consequence. Question 3. What is legal relevance? Legal relevance is evidence that helps decide the legal issue of the case. Question 4. What is conditional relevancy? Conditional relevancy occurs when one item's relevance is conditioned on the relevance of another piece of evidence. Question 5. Is irrelevant evidence ever admissible? No, and this is in Rule 402.
You're doing great so far. Let's take a quick study break to remind you to take your headphones or AirPods with you when you go for a long walk or workout, so you can listen to these videos whenever your hand's free. Remember, every little bit counts. All right, let's get back to questions 6 through 10.
Question 6. What is the Rule 403 balancing test? The Rule 403 balancing test states that relevant evidence may nonetheless be excluded if the probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Question 7. What is the only time that evidence is admissible without using the 403 balancing test? The only time is when a witness has been convicted of a felony or misdemeanor involving dishonesty, and it's less than 10 years old. In this case, there's no discretionary balancing test, and it will be admitted even if it has a serious prejudicial effect. Question 8. What is direct evidence? Direct evidence is evidence that proves a fact or set of facts without the need to draw an inference. Question 9. What is circumstantial evidence? Circumstantial evidence is facts that logically establish other facts via an inference. Question 10. What is demonstrative evidence? Demonstrative evidence is evidence prepared in anticipation of trial, such as a poster, photograph, or diagram, to assist the jury or fact finder. These upcoming evidence questions cover authentication and expert testimony. All right, let's get started. Question 1. What is tangible evidence? Tangible evidence is documentary evidence and other physical objects. Question 2. What is demonstrative evidence? This is evidence that is representative or illustrative of an object or situation, for example, an animation of a car crash. Question 3. What is authentication of evidence? All evidence must be authenticated, in other words, proven genuine, before it may be admitted. The proponent must establish that the object is what they are claiming it to be, and the final decision as to whether the evidence is authenticated rests with the jury. Question 4. When is authentication not necessary? Authentication is not necessary when the parties have either stipulated to the facts or a party granted a written request for admission. Question 5. What are examples of methods by which evidence can be authenticated? According to Federal Rule 901, evidence can be authenticated by either testimony by a custodian of records, testimony by a person who prepared or created the document, testimony by someone who witnessed the signing of the document, or by an expert witness who's qualified to give an opinion, or by showing the trier of fact, the jury, a comparison of the unauthenticated evidence with an authenticated specimen. Question 6. What is self-authenticating evidence? Self-authenticating evidence is evidence that is so self-evident that it requires no extrinsic evidence of authenticity in order to be admitted. For more information on this, look at Federal Rule of Evidence 902. Question 7. What are examples of types of evidence that are self-authenticating? Examples of self-authenticating pieces of evidence include certified copies of public records, official publications, newspapers, trade inscriptions, commercial paper, notarized documents, anything that a federal statute declares to be authentic, or any certified records of a regularly conducted activity. Question 8. How can a physical object be authenticated? There's generally 3 main ways that a physical object can be authenticated. The first is via personal knowledge, meaning the testimony of a witness with personal knowledge that the item is what it's claimed to be. 2, by its distinctive characteristics, meaning it can be authenticated by its contents, substance, internal patterns, or other distinctive characteristics of the item. And lastly, it can be authenticated by the chain of custody. Question 9. What is authentication by chain of custody? This proves that the item in court has not been materially altered or tampered with. Every single witness who handled the object must testify and state, first, when the witness took custody of the evidence and from whom or where. 2, the precautions taken to preserve the evidence. 3, they must testify that the item was not substituted nor tampered with while in their custody. And 4, they must testify when the custody of the item was relinquished and to whom. Question 10. How are reproductions, for example, diagrams, authenticated? Reproductions can be authenticated by the testimony of a witness with personal knowledge that the item is what it's claimed to be. Now note, it does not need to be testimony from the creator. It can simply be anyone with personal knowledge as to the object's authenticity. These upcoming evidence questions cover privileges. All right, let's get started. Question 1. Do the Federal Rules of Evidence have rules on privilege? No. The Federal Rules of Evidence have adopted federal common law privileges, and this is found in Federal Rule 501. Question 2. What is testimonial privilege? Testimonial privilege allows a witness to refrain from disclosing certain knowledge. Question 3. What are the basic testimonial privileges? There are 5. First, attorney-client. Second, psychotherapist client, third, spousal, fourth, doctor-patient, and fifth, clergy penitent, although this is only in some jurisdictions. Question 4. What is required for a privilege to apply? For a privilege to apply, the person must show that the persons in the conversation were in a protected or privileged relationship, that the communication was intended to be confidential, the holder must be asserting the privilege must not have been waived, and lastly, no exceptions can apply. Question 5. When does the presence of a third party not destroy privilege? The presence of a third party does not destroy privilege if the third party is essential to the conversation, for example, a translator, or if the third party's presence was unknown to either party.
Okay, let's take a quick study break to remind you to breathe deep through your abdomen, not swallow through your chest. The more oxygen that you can get in with each breath, the better memory retention you'll have. All right, let's get back to questions 6 through 10.
Question 6. When is privilege waived? A privilege is waived if it's either not timely asserted, if it's waived in a contract, or if the holder intentionally tells a third party about the communication. Question 7. What is attorney-client privilege? Attorney-client privilege is a privilege held by the client that protects communications intended to be confidential, made for the purpose of seeking professional legal advice or services. Remember, this does not cover anything that you say to an attorney. It only covers communications made for the purpose of seeking professional legal advice. Question 8. Who does attorney-client privilege apply to? It applies to the client, as well as the lawyer, and also anyone employed by the lawyer to assist in the delivery of legal services. So paralegal, secretary, private investigator, etc. Question 9. In a corporation, who is protected by attorney-client privilege? Those protected by attorney-client privilege are all employees who are either directed to communicate with the attorney or are communicating pursuant to their corporate responsibilities. Question 10. Under what circumstances does attorney-client privilege not exist? Attorney-client privilege does not exist if the communication was sought to facilitate a crime or fraud, the lawyer's client is now deceased, and disclosure is necessary to effectuate a will, the communication is necessary for the lawyer to defend him or herself, or the lawyer had two joint clients who are now adverse to each other. These upcoming evidence questions cover hearsay. All right, let's get started. Question 1. What is hearsay? Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Hearsay is inadmissible unless an exception applies. Question 2. Who qualifies as a declarant for hearsay? A declarant must be a human being. Evidence from animals or machines are not considered statements for the purposes of hearsay. Question 3. What is considered a statement for hearsay purposes? A statement is either an oral assertion, a written assertion, or nonverbal conduct or gestures, if the person intended it as an assertion. For example, shaking your head yes or no. Question 4. What type of statements do not constitute offering to prove the truth of the matter asserted, and thus are considered non-hearsay. Statements that are considered non-hearsay include statements that have independent legal significance, such as defamation or transactional words. 2, statements to prove the state of mind of the declarant or the listener. 3, statements that show the effect on the listener. For example, to show that the defendant saying, "I'm going to kill you," frightened the plaintiff. And lastly, statements offered solely for impeachment are considered non-hearsay. Now be really careful here. Some statements are admissible because they are non-hearsay. Some statements, however, are admissible because they are hearsay and qualify under an exception. Question 5. Are statements by an opposing party admissible as non-hearsay? Yes. Out-of-court statements made by a party to the litigation are always admissible as non-hearsay when offered by the opposing party. Question 6. What type of opposing party statements are considered non-hearsay by the Federal Rules of Evidence? First, judicial or personal admissions. Second, adoptive admissions. And third, representative or vicarious admissions by an agent or employee in the scope of the relationship, by an authorized speaker, or by co-conspirators. Question 7. What type of declarant witness statements that would otherwise be hearsay are considered non-hearsay under the Federal Rules of Evidence? There are 3. The first is prior sworn inconsistent statements. The second, prior consistent statements. And lastly, a prior identification. Remember that these are not hearsay exceptions. They're considered non-hearsay or hearsay exemptions. Question 8. What is a judicial admission? A judicial admission is a statement made by a party in the current litigation that was either made in the pleadings, during discovery, or during trial. These are admissible as non-hearsay. Question 9. What is an adoptive admission? An adoptive admission is a statement made by another person that the party adopts or agrees with. Generally, there's 2 ways that you can adopt. The first is expressly, meaning clear words of agreement, or you can also adopt by silence, as long as the party heard and understood the statement, a reasonable party would have denied and responded to the statement, and the party did not in fact deny or respond. Remember that failure to respond during a custodial interrogation after Miranda warnings does not constitute an adoptive admission. Question 10. What is a representative or authorized admission, also called a vicarious admission? These are statements made by another that are imputed to the party, either because the party is authorized or there's a special relationship with the speaker. There's generally 3 types. First are statements made by an employee agent. Second, statements made by an authorized speaker. And third, statements made by co-conspirators. And that's the end of our evidence study round. To reach full mastery, remember to study in Brainscape. Our mobile and web app uses the latest in spaced repetition techniques, allowing you to optimize your study time and track your progress down to the finest detail. Of course, when you're driving, cooking, exercising, or otherwise unable to navigate the app, be sure to keep listening to the rest of this hands-free studying playlist. No matter what subject you're learning and what method you're studying it, Brainscape helps you rise to your challenge.